In this short video, we're going to be taking a look at deceptive similarity, which is a part of trademark law, and specifically the application of the test for deceptive similarity in the case of Henschke & Co. and Rosemount Estates. This was a case heard by the Federal Court of Australia in 2000, and it concerned these two wine manufacturers. What we're going to do is take a brief look at deceptive similarity in general and what legislation covers the law. We're then going to take a look at the case as a whole before diving into the application of the deceptive similarity test to the Henschke and Rosemount case. The first thing we're going to do is take a look at what exactly deceptive similarity is. Now, it's covered by the Trademarks Act 1955, and in specific, Section 10 and Section 120. Starting with Section 120, the Act states that a person infringes a registered trademark if the person uses as a trademark a sign that is substantially identical with, and we don't need to worry about substantially identical for today, or deceptively similar to the trademark in relation to goods or services in respect of which the trademark is registered. Now, you then can look to Section 10 to see what deceptively similar is defined as, where it states that a trademark is taken to be deceptively similar to another trademark if it so nearly resembles that other trademark that it is likely to deceive or cause confusion. Essentially, what this means is that a trademark cannot be so similar to another trademark that it is likely to deceive people into getting them confused. A very basic example of this would be if someone registered or attempted to register a trademark for Coca-Cola. Now, obviously, this is extremely similar to Coca-Cola, which is very well known. Coca-Cola would be likely to deceive people. This is a very basic example, but as you'll see when we look at the Henschke case in a bit more depth, it can get very tricky when the level of deception, or even if there is any deception, isn't quite so clear.
The case was between two wine producers and manufacturers. C.A. Henschke & Co. were the original plaintiff. They're a partnership that had been producing wine since 1958 under the name Hill of Grace. Now, Hill of Grace was an extremely expensive wine. It still is, I believe. In the original case, at one point, they had an expert say that it was second only to Penfolds Grange in reputation in Australia. On the other hand, you had Rosemount Estates as the defendant, also a wine producer since 1969. At the time of the case, they had recently acquired a winery and vineyard known as Hill of Gold, and shortly after that had acquired the trademark Hill of Gold. Consequently, they started producing wine under the name Hill of Gold. Now, Henschke claimed that Rosemount were infringing on the Hill of Grace trademark because the Hill of Gold trademark was deceptively similar to the Hill of Grace trademark. There were a number of other legal issues in the case, but we're only going to focus on this deceptive similarity today.
The test for deceptive similarity is complex and has been developed and refined over the years in a number of different cases, including the Henschke case. It was quite well summarized in the Crazy Ron's communication case, and I've put up here a summary of the steps in the test. Now, in the interest of time, we won't run through these in detail, but just briefly, it is worth highlighting each of them. Firstly, the test for deceptive similarity, unlike the test for substantial identity, is not a side-by-side comparison. It is a question of fact for the court to consider whether there is a reasonable probability of deception or confusion. It is necessary to show tangible danger of deception or confusion, and the court must make allowance for the imperfect recollection of someone with the registered trademark. Finally, the authorities recognize that the concept of imperfect recollection can be applied to trademarks other than those of invented words. And what that means is that a phrase like Hill of Gold can be deceptive. The sources for all of these tests, where they were stated or clarified, is listed there on the slide. In applying the test, the court came to the conclusion that Hill of Gold did not resemble Hill of Grace to the extent that it was deceptively similar. Firstly, they considered a suggestion that there was an internal memoranda within Rosemount that Hill of Gold was likely to mislead or cause confusion. They said that there was nothing in the memoranda which suggested that a purpose in adopting Hill of Gold had been to trade off the Hill of Grace reputation. With this out of the way, the court went on to consider specifically whether Hill of Gold was too similar to Hill of Grace. Firstly, they distinguished this from other cases where the plaintiff had been a larger or more well-known brand, for example, Coca-Cola, and they said that while Hill of Grace was a well-known wine, it didn't have that same level of ubiquity, which would warrant keeping people from having similar names. Secondly, they highlighted that the argument from Henschke that all Hill of names should be stopped would have made the scope too broad. So, for example, blocking Hill of Goanna. They said that this was needlessly broad in scope. This left them to consider specifically whether Hill of Gold and Hill of Grace were too similar. They said while there were some phonetic similarities, the definitions of the words, as well as their use, that being grace and gold, were not so similar that people would confuse or be misled into thinking that the Hill of Gold wine was in fact Hill of Grace. This left the court with the answer that this was not deceptively similar, and that Hill of Gold are free to continue to produce their wine.